From Mickey Mouse to James Bond to the Batmobile, fictional characters aren't just the heart of our favorite stories, they're also among the most valuable assets in entertainment. But how do you protect a character? What makes one eligible for copyright protection? And how does trademark law fit into the picture? I'm Scott Hervey, a partner with the law firm of Weintraub Tobin, and today I am joined by my partner and frequent briefing contributor, Matt Sugarman. We
Hey,
are
Scott.
going to talk about the protectability of fictional characters, what's required for copyright protection, how trademark rights can supplement it, and why this matters for studios, creators, and brands on today's installment of the briefing. Matt, welcome back to the briefing.
Thank you, Scott. It's good to be here.
This is a good topic, and I think it's particularly relevant for some of the clients that you represent.
Very relevant.
One of the leading cases on this issue is DC Comics versus Toll. It's better known as the Batmobile case. It's great for providing a clear framework for determining when a fictional character can receive copyright protection.
That's right, Scott. That case involved Mark Towell, who was selling replicas of the Batmobile from the 1966 Batman TV series and the 1989 Tim Burton film. DC sued not only for trademark infringement resulting from the use of the various Batman logos, but also for copyright infringement, arguing that the Batmobile was a protectable character, not just a car.
Right. The trademark claims were, I think, relatively a slam dunk, but the copyright claims were fairly novel. And the Ninth Circuit agreed with DC Comics. The court held that the Batmobile was a sufficiently distinctive element of the Batman works and therefore entitled to copyright protection. The court emphasized that copyright doesn't just cover the entire work like a movie or a comic book, but also sufficiently distinctive elements like comic book characters contained within the work.
That's right. The court recognized that not every fictional or visual character deserves protection. To separate protectable characters from the generic ones, it set out a three-part test. And that test is, as the Ninth Circuit wrote, to qualify for copyright protection, a character must, one, have a physical as well as conceptual qualities, two, be sufficiently delineated to be recognizable as the same character whenever it appears, displaying consistent identifiable character traits and attributes, and three, be especially distinctive and contain some unique elements of expression.
So let's jump into that, Matt. Let's unpack that test, and let's talk about the first factor, physical as well as conceptual qualities. So, what does that mean? It means that the character must exist beyond words on a page. It can't be a mere idea or a description.
That's correct. The Batmobile had both of those. It appeared graphically in comic books and as a three-dimensional car on television and in film. As the court put it, it has physical as well as conceptual qualities and is thus not a mere literary character. Compare that to a fleeting literary reference, like a man in a blue coat walking down the street. That's too abstract to protect.
Right, exactly. All right, so let's talk about now the second factor that this character must be sufficiently delineated. Uh, that looks at whether or not the character is consistently recognizable. So, for example, the Batmobile, despite changing over time, always had core features, right? Like a bat-like external features. It's ready to leap into action to assist Batman in his fights against Gotham's most dangerous villains. It's well equipped with futuristic weaponry and technology that at the time was years ahead of anything else on wheels.
Exactly. And the court noted that no matter the version, the Batmobile was always Batman's crime fighting partner. Sleek and powerful, equipped with jet engines, gadgets, a bat motif, as you said, Scott. These consistent characteristics made it recognizable and unique.
Right. And the third factor, that the character be especially distinctive, that is all about originality. The character can't just be a stock figure like a magician in standard magician's garb or a generic secret agent. The Batmobile and many other characters pass that because, well, in the Batmobile's case, it was Batman's loyal bat themed sidekick with a distinctive look, personality, and even a name.
And the Ninth Circuit concluded that the Batmobile is especially distinctive and contains unique elements of expression. It's not merely a stock character.
Let's compare that to other characters courts have looked at. And one comes to mind. So let's go back to the 1994 Super Bowl when Honda released a fairly slick TV ad for its new Del Sol convertible. Do you remember those, Matt? The Del Sol
Remember 'em?
convertible? So in that commercial, a young, well-dressed couple in a Honda Del Sol were being chased by a high-tech helicopter. This grotesque villain with metal encased arms jumps out of the helicopter and onto the car's roof. With a flirtatious turn to his companion, the male driver deftly releases Honda's detachable roof, which sends the villain into space and allows the couple to continue on their speedy getaway. So, who does this bring to mind, Matt?
Would that be James Bond?
Oh, for sure, James Bond, right? So, MGM sued, contending that this commercial violated its copyrights in the James Bond character as depicted in the then 16 films. And MGM moved for a preliminary injunction. The court found that James Bond has certain character traits that have been developed over time through the 16 films in which he appears, regardless of the actor.
And similarly, Godzilla was protectable because he was always a prehistoric, fire breathing, gigantic dinosaur alive and well in the modern world, a kaiju. And of course, Batman himself. The courts have said he's consistently portrayed as a crime fighting vigilante with a bat motif and a moral code. That consistency across films, TV, comics, you name it, cements him as a copyrightable character. On the other hand, not every reoccurring character qualifies for this. The Ninth Circuit in Rice versus Fox Broadcasting found that the mystery magician, a masked magician dressed in standard magician's garb, as you mentioned before, Scott, wasn't distinctive enough. He lacked unique traits or depth, and as such was not protectable as a character.
Right. And that's exactly why Eleanor, you remember the Mustang from Gone in 60 Seconds, didn't qualify either. And we've talked about this case before. In Carroll Shelby licensing versus Halicki, the Ninth Circuit said that Eleanor was nothing more than a car with a name. She had no consistent traits, no personality, and no unique expression. But, the Shelby Fastback was one beautiful car.
And expensive.
Yeah.
Um, all right, that's copyright. But what about trademark protection, Scott? Characters can also function as brands, and that's where trademark law kicks in.
Exactly. So copyright and trademark protection, they protect different things. Copyright safeguards creative expression, story, character traits, while a trademark protects a brand, source identification, the name, the logo, some type of image that tells consumers where a product comes from.
Right. And trademark rights arise from their use in commerce. So if a studio uses a character's name or likeness on merchandise, like Spider Man on a t shirt, and consumers recognize it as coming from Marvel, that's a trademark issue. And once a trademark owner uses a trademark in commerce, that entitles the trademark owner to protection under the trademark rules.
Right. Yeah. Correct, Matt. You don't necessarily need to register your trademark in order to gain protection under the Lanham Act or under state laws, but it is a wise thing to do because when you register a trademark that entitles you to certain benefits, like for example, entitles you to a presumption of your data first use, a presumption of ownership of the mark, constructive nationwide notice if it's a federal registration. So there are benefits to federal registration, but in order for you to uh, enforce your rights in a trademark, you don't necessarily need to have registered
And
it.
Scott, we have seen that before for clients of ours who are trying to get products taken down from websites across the internet that utilize our clients' protected assets.
Right. I will say though, when you're dealing with certain platforms like um, like eBay, et cetera, most of them do require proof of ownership of a mark in order for you to um, get the counterfeit merchandise taken down.
Mhm.
So that's another benefit of federal registration. If you are a studio with a pretty well-known brand, it's likely that you're going to see lots of infringing merch up there. And so you want to get ahead of that, register your trademark so that you can enforce your rights and have the infringing merch taken down from all these sites, like Etsy, etc. Okay, so this, by the way, trademark protection, that's exactly how studios extend protection long after their copyright might expire. Like, for example, Mickey Mouse, right? Certain aspects of Mickey Mouse are in the public domain, but God help you if you use the Mickey Mouse trademark, you're toast. Copyright eventually expires and then the work goes into the public domain, but a trademark can last indefinitely as long as it is used and renewed.
That's right. And we saw this in DC Comics' first Towley too. Towley wasn't just copying Batmobile's design, he used DC Comics trademarks. His replicas had bat insignias, wheel bats, and a bat steering wheel, and he marketed them as Batmobiles. The Ninth Circuit said that was classic willful infringement. His actions were calculated to exploit the advantage of an established mark. That meant he couldn't even assert a laches defense.
Right. And that shows how copyright and trademark often work together. Copyright covers the creative expression of the Batmobile. Trademark protects the brand identity, the bat symbols, and the name Batmobile.
Trademark is also how studios protect ancillary markets, toys, apparel, collectibles, video games, you name it. Even if someone has avoided directly copying the character's look, they'd still run into trouble using the name or imagery in a way that suggests affiliation.
So, okay, Matt, let's talk about what the big picture is here. What should creators and studios keep in mind if they want their characters to be protectable?
First, distinctive expression matters. Give your character unique, identifiable traits, personality, backstory, consistent visual style. Think of characters like Jack Sparrow, Tony Stark, or Wally. They're not just visually distinct, they think and act in consistent, expressive ways.
Right. Second, consistency across appearances. Courts reward continuity. If your character shows up in a sequel or in reboots or spin-offs, the essential traits should remain the same. The Batmobile evolved, as did James Bond. Maybe he de-evolved, depending upon your favorite James Bond. But it always stayed the same Batmobile, and James Bond always had the same kind of essential traits. Eleanor, however, did not.
Right. And third, anthropomorphism helps. Non human characters are more likely to be protectable if they behave or function like people with agency, voice, and or personality. Think of R2D2 or the Batmobile as Batman's partner, not just a car.
Fourth, avoid generic archetypes, right? Copyright doesn't protect stock characters or tropes like the detective or the wizard or the romantic hero with long hair. You've got to build something distinctive that reflects creative expression and not just this kind of normalized idea.
Right. And fifth, layer your IP protection. That means use copyright to protect the expression of the character and trademark to protect commercial identity, the name, image, and associated merchandise. Disney and Warner Brothers are masters at this. Their character names and logos are registered trademarks across dozens of product categories and dozens of countries as well.
That exactly. Yeah. Exactly. And remember, while copyright protection eventually expires, trademark protection can continue indefinitely as long as the character remains in use or the brand remains in use. That's how companies keep their iconic characters legally and commercially alive for generations.
Scott, thanks for having me on to talk about one of my favorite subjects, which is comics and geekery and nerdiness. It's something that a lot of my clients have in common with their properties, and I'm always excited to talk about it with you.
Matt, that's why I knew this episode was perfect for you when we were putting this together. It's always great to have you on the briefing and always great to have your insights. And thank you to our listeners for joining us today on the briefing. If you found this episode helpful or interesting, please take a moment to subscribe, like, and share it with your network. We'd also love to hear from you. Leave us a comment or a review and let us know what topics you would like us to cover in the future. I'm Scott Hervey. I'll see you next time on the briefing.